I'm going to plunge right in because we do have these laws coming into force from Monday, 1st of July.
Time.
This does already set the context, the political context, the philosophical context, and the constitutional context. I will add just a couple of strands to that. And when I speak, I would like us to keep those aspects at the back of our mind to understand where is this criticism coming from? The government has stated that this is part of a decolonizing process project. And therefore, as Tista mentioned, the journey of independence is from the journey from being a subject to a citizen, the citizen which is at the heart of the Indian Constitution, particularly Chapter 3, the objective and purpose of which is to restrain, curb, minimize the power of the state, make the state accountable, all its instrumentalities and agents accountable, and to affirm and guarantee and respect the rights and freedoms that we as citizens and persons have, which inhere in us. What we see happening in this process when we read the BNS, the BNSS, and the Bharatiya Sakshar Sahita BSS is that the journey is now regressing, and we are being mutated from a citizen to a suspect and a mute spectator. And I would illustrate that through some of the provisions that I will speak about. The other aspect that Tista did mention was, yes, there have been many amendments, but why and how? The amendments have come from people's lived experience, they have come from movements, they have come from campaigns. They have not come from a committee, and that committee actually comprised of three men. Professor K.D. Rao, who's presently the Vice Chancellor of Nalsar, Professor Bajpai, who is now the Vice Chancellor of National Law University, Delhi, and Mahesh Jethmalani, the senior advocate from your city, who is affiliated to the Bharatiya Janata Party. The representative character of that committee is before you. Nonetheless, when those questionnaires were posted online in 2020, in the middle of lockdown, because there was some urgency to amend the laws before Amrit Kal dawned upon us, many of us, including Vijay, made a Herculean effort to actually write copious answers to those questions. The process of consultation doesn't mean that I respond and then we don't know what happens to that. The process of consultation is a process of engagement, which we have seen is totally absent both inside and outside the parliament. And it is not surprising, therefore, that we have what we have, where there is also absolute legislative negligence in certain parts, because what is written is incoherent. So it's not even, if there is a criticism based on constitutional threshold, but there is also completely poor drafting where nobody cares what they are writing. The entire criminal legal system, and I think we need to stop calling it the criminal justice system. Words have lost their meaning, and therefore calling it Nyaya Sanhita does not imbue it with any elements of justice. The criminal legal system operates on an assumption that long ago, actually prior to 2014, has been repeatedly hollowed out, and now there is nothing left of it. The assumption that the state, through the police, through the prosecution, will act in good faith. That is not the state of affairs, and there is enough evidence documented both in records created by citizens, which are as legitimate, as well as in the judicial archive, to show that the state is acting in bad faith. And if there is a serious engagement with what is truly decolonization, of the law, then that process would make the state accountable and would actually challenge whether the good faith is to be parked with the citizens rather than with the state. I will now mention some of the provisions to which I would like to draw your attention. Some have been already mentioned in passing, both in what has been written and what are the what are the legal silences, which this was as good an opportunity as any to actually introduce into the criminal codes. Reference was made to sedition, which, as we know, has been stayed as an offense by the Supreme Court. All trials, all prosecutions, etc., of the offense of sedition, section 124A, have been stayed. And we were told, and I will take a little bit of time because I find this absolutely fascinating, the affidavit, the counter that was filed by the Union of India, which actually the then Chief Justice of India reproduced in the order, which said, the Honorable, and because it was in the name of the Prime Minister of India, it is recorded so in the order. The Honorable Prime Minister of India has been cognizant of various views expressed on the subject and has also periodically in various forums expressed his clear and unequivocal views in favor of protection of civil liberties, respect for human rights, and giving meaning to the constitutionally cherished freedoms by the people of the country. He has repeatedly said that one of India's strengths is the diverse thought streams that beautifully flourish in our country. This is the Union's affidavit reproduced. The Chief Justice is not saying that he said it. This is the government saying that the Prime Minister said it. Clearly, there are some secret parleys which you and me may not have heard, but that's all right. They can have their private meetings. The Honorable PM believes that at a time when our nation is marking Azadi Ka Amrit Mahotsav, 75 years since independence, we need to, as a nation, work even harder to shed colonial baggage that has passed its utility, which includes outdated laws and practices, etc. And it says specifically, in this spirit, the government has scrapped laws, etc., which are unnecessary and causing hindrance, have to be decriminalized. The government of India, being fully cognizant of various views expressed on the subject of sedition, and also having considered the concern of civil liberties and human rights, while committed to maintain and protect the sovereignty and integrity of this great nation, has decided to re-examine and reconsider the provision of 124, etc. What comes in place of that? As was mentioned here, what has come? Yes, the word sedition is missing, but the offense has actually been enlarged. It is now so overbroad and vague. Already we had seen, and the reason why the Supreme Court agreed to intervene, and I represented two women editors, Anuradha Bhasin of Kashmir Times and Patricia Mukim of Shillong Times, in that matter, looking at how the offense of sedition silences freedom of press, particularly in these areas. Now we have section 152 of the BNS, the Bharatiya Nyaya Sanhita, which does not use the word sedition, but says endangering sovereignty, unity, and integrity of India, and actually has expanded the offense. And I'll read out one phrase because at least, and there are no definitions in law, in criminal law. What is the principle of drafting that is followed across the globe? The principle is certainty and the principle is precision, because without that, the interpretation of an offense by a court would be both difficult for a judge and would be highly subjective and arbitrary. These two principles are totally absent and missing from the kind of drafting that we are now seeing in the new criminal codes. And the example of that would be, apart from many other words that have been added without any definitions, if talks that are the presentations being made here encourages feelings of separatist activities, how do I understand whether somebody speaking on a controversial subject whether it would encourage a feeling. The police officer is now going to be able to, and we have senior police officers sitting here, the police officer will be able to ascertain not an activity, an action. Criminal law has two elements, mens rea and actus reus. Intention and your act in order to formulate an offense. But a feeling that you may have can actually now come within what was described as sedition 2.0, and there are no definitions for what is separatist activity, what is subversive activity, or indulges in or commits. I've practiced law for 30 years. What is indulge? I understand commit. I can commit an offense. I can attempt to commit an offense. I can make preparation. I can conspire to commit an offense. But what is indulge? We don't know what these words mean. Who will determine? Basically, who is going to determine from 1st of July is the man or the woman sitting at the police station who is going to start using these provisions when complaints, FIRs, etc. are lodged. So this is how the Prime Minister's assurance, not just to people but actually to the Supreme Court of India, has played itself out in drafting of the sedition probe. And as was mentioned again, so what happens to Article 19 and what happens to all our freedoms? And that is the touchstone and the test that every single section in all the three codes will have to meet, without which, when the challenge is made, when the challenge is heard and decided, they will have to be struck down. Then you have the liberty to free speech, expression, assembly, etc., all stand jeopardized. The other aspect here, and this is unparalleled. So yes, for novelty, full marks. Chapter 4 of the Unlawful Activities Prevention Act, the use of which, and I do not think we should any longer talk about misuse or abuse of the law. This is the use of the law. The law is the instrument through which repression will be carried out and is being carried out of everyone, from the political opponent to human rights defenders. Chapter 4, which is from section 15 to 21, has been lifted, cut, paste, and has been parked in section 113, if I'm not mistaken. I'm not up to the mark, and it's very mind-boggling. After 30 years to start learning new numbers, like there's no 420, it's almost culturally tragic. UAPA defines terrorist act. It is the terrorist act where you have to meet the very high threshold of impossible bail under section 43D5, which even the Supreme Court has now been saying, how do you say there is no prima facie case made out, etc. That has been cut, paste, put in the Bharatiya Nyaya Sahita under section 113. Under UAPA, there are at least some formal safeguards, like sanction for prosecution, a review committee to see if the case can be instituted. The Bharatiya Nyaya Sahita is the routine law, is the ordinary law, not an extraordinary law. So what is happening now is the routinization of extraordinarily stringent and draconian provisions which are found in UAPA and in MACOCA are being routinized by bringing them into the Bharatiya Nyaya Sahita verbatim, without even the formality of those safeguards, and thereby not only creating, this is going to create legal anarchy, and that is why it is no surprise that the police officers are delighted. Who gets to decide who will go under UAPA and who will go under section 113 of the BNS, because the offense is identical. Offenses are identical. In UAPA, they're from 15 to 21. In BNS, they've all been clubbed together in 113. This level of arbitrariness, and therefore, when we are told that people can be recognized by their clothes, we don't know what will be the determinants of who will be arrested under what, apart from the very, very dangerous trend of routinizing extraordinary anti-terror provisions which are created the world over. Those laws are passed, to my mind, always wrongly, but they are passed in emergent circumstances to meet certain emergent threats, not the routine law and the ordinary law of the land. There are aspects that have emerged from our experience. One of them being police brutality, torture. There is enough documentation by the National Human Rights Commission and in Supreme Court judgments that torture is a reality in India. India does not have a specific codified offense of torture. We signed the UN Convention Against Torture in 1997. We have told the international community, not only to the people of India, but even the international community, since 2007 repeatedly, that we are going to ratify the convention by introducing a domestic law. The Law Commission of India in 2010 advised the government that you should pass a separate law. This was a great opportunity to do so. There is no offense of torture. Surely in Amritkal, we can at least have some respect for the body of the Indian citizen. Not only does that not get codified, there was a provision introduced in 2005 which said that if there is a custodial death or custodial rape, there is mandatory judicial magistrate inquiry. Many of you would recall the Ishrat Jahan case, which I represented the mother of Ishrat Jahan, who was killed in a fake encounter in Gujarat. The one time that we heard a glimmer of what may have transpired was a judicial magistrate's inquiry under the then section, present section 176(1)(a) of the Code of Criminal Procedure, where he said that this was a fake encounter from his inquiry. They have dropped judicial magistrate, and the inquiry into a custodial death, custodial rape, or extrajudicial killing, which is deemed to be a custodial death, will now be conducted by any magistrate, which means at least in Delhi, we call them subdivisional magistrates, or maybe you call them executive magistrates. I don't know how Bombay's nomenclature, but these are civil servants who work under the government. The reason it was changed in 2005, and it is reinforced in the PUCL judgment of 2014, PUCL versus State of Maharashtra of the Supreme Court, which lays down the guidelines to be followed in a case of extrajudicial killing. So you actually have provisions of the law which are in defiance of established Supreme Court judgments, as handcuffing was mentioned. We have many judgments of the Supreme Court as well as guidelines of the NHRC on arrest, which says only in very, very extraordinary situations, taking permission of the court, you can handcuff. In Delhi, I was one of the counsels in the Parliament attack case, a very big criminal trial in the special court. None of the accused were ever handcuffed when they were brought for their hearing, and the hearings happened. Today, that discretion is not of the court. It is the arbitrary discretion of the arresting officer if he thinks you are a dangerous person, and that can be, how is that to be guided? The other aspect that was mentioned, and on this I was chatting with Vijay just before, I think there is some confusion being created, at least in my mind it's very clear. Personal integrity, bodily integrity, personal liberty stand very, very seriously jeopardized by the amendment to the period and when police remand can be taken. As some of you know, when a person is arrested, as per the present law, which has been the law of this country forever, and nothing so different happened that investigations couldn't be completed that we needed to alter this. The police has a right to take police remand within the first 15 days of arrest. Once the first 15 days of arrest are over, the investigation, of course, can continue, and the filing of charge sheet, if the person is in judicial custody, has to happen in 60 days or 90 days, depending on the nature of the offense. Now, what is being said is the police can still take only 15 days police remand, but at any time over a period of 40 days or 60 days, again depending on the nature of offense. So it's not the first 15 days. So what is the implication? How does it matter? What is police remand in our country? Really, does some breakthrough in investigation take place? We do enjoy Article 20's right to silence, which still stands in the Constitution. So it's not as though some eureka moments of investigation happened in police custodial interrogations. But the fear of torture, the fear of being implicated otherwise, and what we have recently seen in actual cases, both against journalists, human rights defenders, and political opponents, you can be turned into an approver. You can be turned into giving statements against the other accused. That is why that extended period, because after all, it takes time to coerce somebody to tell a lie and to intimidate people, to threaten them in multiple ways and their families, etc., etc. And therefore, that period of police remand total will remain 15 days, but staggered over 40 days or 60 days. The total period will not change. Secondly, now let's imagine a scenario where somebody has to apply for bail. In that 40-day period, actually, there will be no bail possible. The minute you will say, and I'm sorry if it's a little technical, but we are in a state of affairs in the country that we'll all have to learn more than we need to. If you will file a bail within the 40 days period, all they have to come and say in a court is, oh, we still need to take remand. We need to have some more custodial interrogation. Until the prosecution, and these applications are made very casually, because nobody asks them about what are the grounds for remand, but you've already taken remand, what is the new thing you want to ask? So then take remand just now, why are you waiting for the 39th day? Courts are usually a little reticent to ask these questions. And all that will happen is that till those 40 days or 60 days, actually, you are saying the person cannot get bail, because that will be the effect and impact of it. One of the things that the Indian Penal Code has, and that really is Victorian morality at its worst, is the criminalization of voluntary termination of pregnancy. Abortion is a crime even if a woman wants to commit it, because at that time, that is how it was understood under British colonial rule. There are umpteen judgments of the Supreme Court, for Puttaswamy to recently Miss X versus Principal Secretary Health, saying women have absolute autonomy to take decisions on reproductive rights. The Medical Termination of Pregnancy Act actually was introduced to carve out an exception for the doctors and the medical practitioners to be able to conduct the termination of pregnancy. Otherwise, they would have committed a crime. Verbatim, the provisions of law on criminalization of abortion have found place in the Bharatiya Nyaya Sahita. So I'm not sure what is, and jurisprudence has marched forward. And yet we are not seeing any space for acknowledging women's autonomy over their own lives and bodies. Similarly, Section 377, finally read down in Nafte Johar by the Supreme Court, was retained only to the extent of non-consensual sexual assault on adult men. We have POCSO for boys and girls. An adult male upon whom sexual violence is committed, or even a trans man, and we know that sexual violence on trans community, their bodies are targeted, particularly in custodial situations and police, etc. There is documentation to that effect. Recently in Karnataka, Prajwal Ravana's brother has been arrested under 377 because Suraj Ravana. Let's imagine a crime of that nature committed on 1st of July. There is no provision of law. You have created a gap in the law, and that is what happens when you do not consult. Groups that are vulnerable to this kind of violence, and there is no conversation with them or in Parliament, that there will be challenges in the court, in the constitutional courts, the High Court and the Supreme Court, to these laws. But we are also looking at chaos and the kind of legal mayhem. And who will bear the brunt of that legal mayhem? Who will, if the court is saying this is the law, how will we argue? Who will decide under which provision of law? At least I presently don't know. There are annotated criminal manuals, and all we are doing is going cross-eyed, trying to see what happened. And that's when I said, if today we were to say 302, everybody knows it's murder, 420 is cheating, it's not from 1st of July. So what is the reason to create this level of mayhem? Is it not disempowering for people? How does every ordinary person today get to suddenly overnight, I can't claim that I know the new sections, get to know what is the law, what are the changes, what are the powers that the police have got. So it's also about what is this machinery of the government trying to do in our midst. And as I said, there will be challenges. Challenges to such matters, as we know, take very long. Tista, myself, we have all challenged the anti-conversion, so-called freedom of religion, but actually anti-conversion laws, which are having a direct impact, particularly on the lives of the young every day who are being arrested. The challenge is pending for long since in the Supreme Court. It's not been heard. Sedition is in abeyance. But from 1st of July, what is the new monstrosity in our midst? Therefore, these conversations are very important, because according to me, it's not just about the constitutional challenge. I think the real challenge has to come from our midst. These laws are for us, and we will decide what the laws will do. Thank you.